Hello, everyone. My name is Hannah Risley, and I'm the reference librarian for the Duncan Branch Library in Alexandria, Virginia. We are closed right now, but we're still doing a bunch of our stuff virtually. So virtual programs, ebooks, electronic reference, and if you call our branch number, somebody's there Monday through Friday, 9 to 5 to answer your questions. So feel free to reach out to us with any information needs while we're closed. I just want to give a quick thank you to the Friends of Duncan Library. The Friends of Duncan Library are the ones who generously pay for the Zoom account so that we can have these programs as securely as possible using the webinar feature. So if you'd like to support future programs like this one, we're going to be doing virtual programs all through the summer, even after we reopen, to promote social distancing. So if you'd like to give back or help fund those programs, consider becoming a friend of Duncan Library. You can find the Friends of Duncan Library at friendsofduncanlibrary.org. You can also visit the Alexandria Library website to give to the whole system through the Alexandria Library Foundation. That website is alexlibraryva.org. Tonight's presenter is Brian McAvoy. He will be speaking to us about estate planning and how it's changed during the pandemic. If at any time you have questions for Brian, you can put them in the chat box or in the Q&A box. He'll have built-in breaks and I'll come on and ask some of your questions. So just put those in the boxes, I'll see them and relay them to Brian. All right, Brian, I'm gonna let you get started.
Well, thank you so much, Hannah. Thank you to the Duncan Library, and thank you all the attendees watching from home. And I really want to let you know that I appreciate your attending and your time. As you have been seeing on this first screen, we do have a little icebreaker. And as I mentioned, if you showed up a little bit early, that I will be making sure to tie it into the presentation. And also would really like to hear about your recommendations for some of the best takeout that you've been getting in this time of curbside pickup. As Hannah mentioned, I am Brian McAvoy of Smolin Plevy here in Tysons. You'll see my contact information down at the bottom left there. It'll be at the final screen too. I'd be happy to hear from you if I don't cover anything, if you've got more questions. But we are happy to address your questions if you have them. I also do want to touch upon that little note bottom right there. Nothing here constitutes legal advice or establish an attorney-client relationship. And any specific advice that you'd want, we would have to follow up in a consultation. With that said, I do want to let you know that all of us here and everywhere, we are experiencing this same very, very different time, challenging time. We are humans. I am a parent. And so I completely realize that you have some extra concerns. I will be addressing some of those. And yet at the same time, one of the things that we are doing, or several of the things that we are doing, we are taking steps to socially distance. We are wearing masks. We are taking proactive steps to take care of ourselves, our parents, our children. And those steps, having a plan in place, are the ways that we can have some agency over this challenging time. And generally, when we experience challenges, having a plan and taking those steps can be one of the best things we can do to combat that. And that is essentially the peace of mind that I got from coming into estate planning and drafting my first estate plan. I'll tell you how I got into the realm, but that is the very thing that we're here to talk about tonight, and one of those helpful steps that we can take. Well, as you see, there are my two daughters, Sage and Morgan, and I'll be telling a little story about how I got into estate planning in the first place, and they are the reason. I attended law school initially to be a constitutional litigator, and I was arguing appeals before the DC Court of Appeals. I actually quite enjoyed it, and was carrying on a solo practice in appellate litigation when about 8 years ago, along came Sage and Morgan. You are going to see some gratuitous pictures of my beautiful young daughters. But as I said, they are the reason that I got into the estate planning business. My first daughter, Sage, was born, and my wife turned to me and said, I know we probably need wills or guardians or something. You're the lawyer, you go figure it out. And so I did. I hit the books that I had thankfully saved from law school, put together a first draft of an estate plan, and then I put together another draft, got more and more experience, did the trainings, and before too long, I was hearing from friends who were welcoming their first children and putting together the plans for them as well. And before too long, my estate planning practice was overtaking my appeals, and I was up and running. I joined Small and Plevy here to reach even more people and have really enjoyed that work. And I've found that helping people put in place the plan that makes them feel most comfortable is one of the most rewarding experiences that I've had in being an attorney. Well, generally speaking, here is the question that we address in estate planning. What would happen if something happened to you? We are addressing both what happens in the short term, meaning what if you are hurt or injured and unable to tell us what you want to have done with your assets? And then in the long term, what happens when you do pass away? Now, as I said, we are going to be dealing with some challenging, difficult to comprehend and perhaps discuss challenges and topics. You'll see me cut in a little bit of humor to make it a little bit easier to talk about. But again, the thing I want to bring us back to is if the topic gets too hard to think about putting in place that plan that makes you feel better about those questions. And that's the thing that we'll come back to in this presentation. Now, we're going to start with that second question first. What is the probate process? What happens after we've died, and what happens to our belongings? Well, the probate process handles your assets when you cannot. The probate process is there to essentially prove where your assets should go. In fact, that word, probate, comes from the Latin root for prove. Now, what typically tells us where your assets go? Well, as you see there, typically it's a will. Now, I want to pause and I want to go through a bit of an exercise here. I want everybody mentally, not actually, but mentally, go ahead and raise your hand if you have a will. Now I'm going to look around the room. No, I can't actually see you, and no, we're not in a room. But I am so glad to see that everybody's hand is up. You're saying, wait, no, I don't have a will. I am one of the 67.3% of people that has not put together a will. Well, you have a will anyway. That's where that other word comes in, the intestacy statute. Every state has essentially a will that will be your will if you have not written your own. Now, probate gets a pretty bad rap. Then there are some challenges associated with it. As you see down at the bottom there, time, costs, and privacy. The probate process does take some time. There are costs associated with it. And as it's a public process, it's essentially a court filing. It's a court case. And that is a public process. We are going to talk about an alternative to that later on when we discuss trusts. Now, that probate process, one of the costs associated with it in some states is the estate tax. So we're going to talk about that briefly. Now, the estate tax, and perhaps you've heard a little bit about it, the federal estate tax currently has an exemption, meaning a level at which if you don't have assets that reach this level, which is actually $11.53 million, then you will not be assessed an estate tax. That's the federal estate tax. The state estate tax, I like to say that nice and slowly to make sure I don't trip on my words there. The state estate tax here in Virginia is actually zero. There is no state estate tax. Different in different states, and I might be speaking to folks tuning in from other states. So here I'll call back my proviso. This is not specific legal advice. I will speak right now to Virginia. However, there is a joke in the estate planning world that we lawyers tell, and that is, I can't tell you two things. I can't tell you when you're going to die and what the estate tax is going to be when you do. This is something that moves. And the exemption has gone up, but that trend is not necessarily guaranteed to remain that way. And Virginia has no state estate tax, but that is not something that is set in stone either. I'm going to move on to the next slide here, a little bit more about wills. How about that will that you have if you didn't write your own? The Intestacy statute essentially says that if I die, everything goes to my spouse if I have one, and if not, then to my children. And if not to my children, we have an heir tree that it goes to past there. It's nicknamed the sweetheart will, because my things will go to my sweetheart. And if not, our children, and so on and so forth, guided by the heir tree. Well, what is in a will? And let me translate that into what I really mean here. What is going to be governed by the will? I will grab a sip of water and you think about that. While you're doing that, how about that second one? What isn't covered by the will? What's in the will? Well, essentially, it's everything that you owned in your name alone that wasn't held jointly with somebody else and that didn't have a beneficiary designation on it. Well, that kind of implies the answer to that second question, right? What isn't in a will? Well, it's those things I mentioned, things that are held jointly, things that have beneficiary designations on them. And increasingly, some of our largest assets will be those things that I described, something held jointly or that has a beneficiary designation on it. Essentially, we always make sure when we're having a consultation that we talk specifically to that question. For example, somebody might say in their will, I want to make sure that I spread things evenly between my children, but I also want to make sure I have something that goes to my godchild, so-and-so. Well, if that beneficiary designation, maybe that large stock portfolio you have, maybe that 401k designates the children, even though in your head you thought you were dividing everything amongst those people that you wanted to divide it amongst, those beneficiary designations are going to govern that asset. And so that is always part of the process that we estate planning attorneys go through. Make sure we talk about what are those assets and where do you want to have them go. Well, I have been seeing some questions come in, and this is a point at which I want to pause and take a couple of those questions. Oh, there's Hannah again. Okay.
All right, so Jeremiah asks, can I have a joint will?
Can you have a joint will? I want to see if there's another way to interpret that. The short answer is no. But can I put together an estate plan that that takes into account that I am talking about assets that are held jointly? Certainly, when we do estate planning with married couples, we are going to talk about the assets that they hold jointly and consider those when we put both the wills and trusts, if they apply, together. And so I will put the answer that way, right? Joint will as a standalone document, no. But the estate plan, yes.
All right, and Brittany asks, she's curious, have you seen an uptick in business since the pandemic has started?
Yes, yes. From both, general inquiries to a Zoom meeting that was capped at 100 that we exceeded. Yes. Now, what we tend to talk about in estate planning there are sort of these triggering events in a life and I spoke about mine, right? How did I get into estate planning to begin with? The birth of a child, a health scare, a big one that we encounter is actually people going on trips. And they kind of think about, well, wait a minute, I'm leaving. It's a remote risk, but I don't know that I have everything put in place in the way that I want to. We absolutely have seen an uptick in inquiries. And what I want to bring us back to is exactly what I said earlier. This can be a way to make sure that you have the plan in place that you want. And there are actually concrete benefits to having an estate plan put together in a time of a pandemic. And we're going to talk about that specifically when we talk a little bit more about powers of attorney.
Claire asks, is there a difference between a will and an estate plan?
Right. Yes, a will is a component of the estate plan. I am going to actually call that back as well when great questions, when I talk a little bit more about trusts. Now, a trust can also be nicknamed a probate substitute. And in certain scenarios, I am calling back, a case in estate administration I did work on where the will did not come into play much at all. And that is because almost everything was, almost all assets were titled jointly, beneficiary designated, and or placed into a trust. But even in that case of a probate substitute, a trust, we put together what's called a pour-over will. A will that basically says, anything that I have not titled to my trust, here's the name of my trust in my will. I want all of these assets to go over to my trust. Anything that has poured over from my estate planning should go over to the trust. So yes, that's the answer. It's a component part of the estate plan.
All right, and one more good question before we get into the next part. I think this might lead into your next part.
Okay.
Laura asks, is an estate plan the same as a trust?
Yes, so a similar thing, and again, the short answer is no. The short answer is no, and that a trust is a component part to an estate plan. And so a trust, though, as we're going to talk about a little bit more in detail, can absolutely be a very flexible document that can stand in the place of some of these other documents. Now, that said, we always put together a full package of documents because we want to plan for as many scenarios as possible. We plan for the moment, but we also want to have a plan with plenty of contingencies. And so same answer there. The trust is a component part of the estate plan, but not the same thing, and should be accompanied by other documents.
All right, we have several more questions about trusts specifically, so I'll save those. I have noted your questions. If they haven't already been asked, feel free to keep sending questions in.
Fantastic. Okay, I'm going to get another sip as well. Well, great questions, everybody. And I see that there is an appetite to learn a little bit more about trusts. And let's see if we've got, hey, there it is. What in the world is a trust? Well, I am going to start from a pretty ground up introduction to what a trust is, what it isn't. And then I'll get into a little bit more of the granular as to, how can this document be very helpful in estate planning and generally a flexible document that can be very helpful. Well, the definition is it's a three-way agreement between yourself, and yourself. A bit of a joke there too. When you are living, you are the grantor, meaning you are placing your assets into this trust. You are the grantee, meaning you are you are the beneficiary, meaning these assets are for you. And you are the trustee, meaning you are the person in charge of these assets. And so the full title of a trust is a revocable living trust. This is a trust that is revocable, meaning you can take things out, you can revoke it, it can be changed during your life living trust. Now, a lot of that might have sounded a little bit like legal jargon, that kind of thing, and that's why I like to use a metaphor to really get a better, fuller definition of what a trust is. Some people use the metaphor of a corporation, and that fits. I tended to work with parents of young children early on, and so I used a little bit more applicable to us parents of young children, the little red wagon, that radio flyer wagon that you can put your items into, pull it around. A trust is essentially a little red wagon. It's a wagon that you put your things into. It's got an instruction booklet strapped to the side. If something should happen to you, and let's use the example of something has happened temporarily, you've gotten hurt, you are in a coma, you're going to recover, maybe, hopefully. Let's say in this scenario, you will. But right now, you can't tell us what to do with these items. But your trust can. It has a little instruction booklet. Not only does it have an instruction booklet, it has a person named behind you to take control, right? So they are named and they have instructions. Here's what to do with my stuff, okay? Now, you regain capacity, you can pick that handle back up and you have your little red wagon. And that is an example of how, in a big way, a trust is different from the will. The will does not come into effect until and unless you die. The trust is there for both scenarios. And we're gonna talk a little bit more about that and its benefit. Now, let's talk about that other scenario where unfortunately you do die. You had your trust, you put your assets into it. Same scenario applies. You have a successor trustee named, meaning just the person in charge after you. And they have that set of instructions. What do I do with these assets? Now, these assets can be those beneficiary designated assets. They can be designated to the trust. Again, that's something that we go very specifically, asset by asset, when we work with clients. And here, to that final note, how a trust can replace probate. Well, essentially, if as many assets as possible are passing through the trust and or the designations, the beneficiary designations you made on your assets themselves, well, then really there are no assets that were held in your name alone. That is where assets held in your name alone are going to go to probate. Here in Virginia, we have a small estate affidavit that if your assets are below $50,000 or even lower than that, below $25,000, we actually don't even have to go through the probate process. Everything passes through the trust, and that is a way that a trust can replace probate. Now, there are additional assets to, I shouldn't use the term asset, there are additional benefits, there are additional things that are very useful about using a trust. Essentially, you can also title your real estate to your trust. This is especially applicable if you have real estate or assets that are in other states. The probate process, there you would have to open different probate cases, different probate filings in different states, especially for real estate. Whereas the trust, if you title your real estate to the trust, then the successor trustee will have control over that real estate without it having to pass through probate. Another set of clients that I tend to work with are military families who might be facing relocation, uncertain about what are the different laws going to be from state to state. Certainly a will be honored, but a will tends to be written keyed more toward the rules governing that state. Whereas a trust, you can essentially select your law. You can say this trust is governed by the laws of the state of the Commonwealth of such and such. Another great benefit of the trust is that incapacity that I spoke to. If you have real estate that, or any other, very valuable assets, and again, that scenario of someone has been injured, they are in a coma. Now here, if you are dealing with someone who lacks capacity, but is still alive, anything passing through a will cannot be governed by that will, because that will only comes into effect when you die. Here, with a trust, that asset will be controlled by the successor beneficiary, the successor trustee, who will take control of that asset and be able to sell real estate, make those transactions. That is another perk of the trust. I do want to call back our icebreaker, especially as I transition from this slide where it does apply to the next one, where it certainly applies. You gave me some great ideas as far as your favorite restaurant, who's doing takeout now, and one of our favorites is the London Curry House over by us in Alexandria City. They're doing some great carry out, curbside pickup. We were very happy with it, but my wife and I would really like to get back there for, mommy, daddy date night. And so let's paint the scenario of it's safe to go back to the restaurant. It's open. We go there. We finally line up a babysitter for Sage and Morgan. And I'm going to make this a little funny, a traveling salesman that brings that sleeping gas from dentist to dentist has stopped by to get a meal at London Curry House as well. One of those canisters, well, he couldn't leave it in the car. He brought it with him. It falls over. It fills London Curry House with sleeping gas, and we fall asleep. Again, those of you that are parents are thinking of this and thinking, that sounds wonderful. I can't think of the last time where I got a good night's sleep. So here we are asleep at the restaurant. Now, let's unfortunately make that a little bit more of a challenging situation. My wife and I, we actually do have some complications because of this. We are at the hospital. We cannot tell our successor trustee what to do, but we do have a trust. we have a trust that establishes here are the successor trustees that can control our assets. Should we lack capacity to do so, we have also named, we have our, here we go, powers of attorney. We have designated people to control our assets, and we've put together an advance directive, a living will. Here are the types of procedures we do not want. These documents are in every estate planning package that we put together as well. These are absolutely essential. And you can see how the trust and that power of attorney does have some area of overlap. Again, the trust is a very flexible document. But for more straightforward transactions, financial transactions, who can control your assets while you were alive, that is a very key component here when we're talking about powers of attorney. That document is a very, very important one, including the healthcare power of attorney, the person that can bring about those wishes that you state in the advance directive, more commonly referred to as the living will. Now, we hope that we don't face these situations, but again, we put these plans into place to have that peace of mind and to overcome those challenges when and if they arise, or at least make sure that the plan proceeds as we want it to. I know that we're probably going to get a few more questions about the powers of attorney, but I want to speak to this a little bit more. Powers of attorney increasingly include control over our digital assets. We make sure that we update our language there, as so much of our lives are transitioning to that digital world, making sure that we empower our agents, our power of attorney agents, to have control over those assets, are aspects of the power of attorney that we make sure that we bring about as well. Okay. Now, another question that we could linger on and spend a lot of time with, and sometimes we do in our consultations, believe you me, my wife and I spoke a lot about this one as well, are naming guardians. And how should we choose them? How many should we list? What factors should we consider? Ultimately, this is a very personal decision, but just a general guidance I like to give is that some folks do come right back to thinking about, frankly, money, the amount of assets that are going to be there, and in putting together your estate plan, making sure those assets that you have that can be passed along, that's the side of things that you are in control over. It can be helpful to broaden your thinking as to, what do you want in a guardian and a successor guardian. I am not going to speak to these questions too much, but I know that when we consult with parents in putting together their estate plan, these are questions that they certainly have, and many of us estate planning attorneys went through that process ourselves. Okay. Now, estate planning during COVID-19. This one is certainly something that somebody asked about earlier, and something that has certainly been a challenge on our end of things. I'll speak to a few aspects of this. Up front, one of the challenges, right? How do we sign these documents when we can't gather in the numbers that these documents call for? Most of these documents call for 2-3 witnesses, a notary. If we're dealing with spouses, there's another person. And so essentially just the amount of people that you would have to put together to sign these documents can be a challenge. Additionally, there is a challenge in the form of the UETA, the Uniform Electronic Transactions Act. On one end of things, Virginia has actually been a bit of a pathfinder in the way of opening up remote signing. And more we can sign documents and notarize them from anywhere. However, there is a noted exception in that law for wills, and they cannot be signed and notarized going through the Electronic Transactions Act. Now, we have found ways to make sure that we get these documents executed. And first, I want to say the good news, much of this process can be done remotely. From initial consultation to any follow-up information, calls, the building of these documents can be done up to signing almost 100% remotely. I should actually edit that to 100% remotely, if that's the way that we choose. Now, pardon me, when the documents are ready to be signed, how have we gotten them signed? Well, I actually got some intelligence from a friend of mine who does signings of deeds, and she transitioned to signing them outdoors. As long as we have either good enough weather or a shelter over our heads, we can all create some space, sign the documents, making sure we respect the space that keeps us all safe, and get that signed in ink. And that's one way to do it. Another one that we've done is essentially sign all of the rest of the documents and make sure that we have the will put together and ready to go when it is safe to do so. And increasingly, we are seeing a space where it is safe to at least get that signed with as few people as we can, and make sure that we have that plan in place that you choose. But one way or another, we are getting documents at least started and ready to execute for when we can find that safe time. Well, here's our summary, our outline of what we covered. We started by talking about the probate process and intestacy and what that means, and the fact that you all have wills. Congratulations. If you came in thinking you didn't, well, you do now. No, you had it before, of course. However, I still advise going about and putting that plan that you choose in place. We talked about wills and what's in them and what's not. We talked about trusts and how it's a great flexible document that can essentially be a probate substitute, powers of attorney and living wills, and planning in the COVID-19 era. Well, I do want to pause and take any more questions that we might have. And there's Hannah again.
All right, so we actually got a question before the presentation ever even started. Does a revocable living trust written in Virginia remain in place if I move to another state?
Yes. That is a good question, and I spoke to that briefly, but absolutely, they are. That is another one of those very beneficial aspects of a trust and its flexibility.
And then Elizabeth has another question about moving out of state. She asks, hello, we have a will and guardianship which was developed while we lived in Massachusetts. Our daughter is now 24 and we live here in Virginia. Should we make a new will?
So as an estate planning attorney, should I make a new will? The answer is pretty much always yes. That's a little bit of a joke, but no, calling to this specific scenario, again, not specific legal advice, and I'd want to be able to really look at the full scenario. But generally speaking, let me broaden this. Every 3 to 5 years is a really good time frame to revisit your estate plan. Maybe not rewrite things, maybe just tweaks. But this question does call to some of the substantial changes that can happen, and a move is a big one. Now, there are The answer to this is perhaps not much changes in that will. I have not seen it, but perhaps a lot does. And one of the scenarios that I did, or one of the aspects that I did speak to earlier is wills are very frequently written keyed to the laws of that particular state or commonwealth. As I went to undergrad up at Boston College, I happen to know that that's a commonwealth too. However, the Commonwealth of Massachusetts and the Commonwealth of Virginia might have very different laws, and it's a good reason to at least take another look at it.
All right, thank you. We have two different questions about real estate and trusts. The first question, I'll give you both of them. I think they might be a little similar for you. Carol asks, if you put your house in a trust, what happens if you sell it? We also had a question, does home ownership by a surviving spouse go to the next person in line, such as a son, if it exists within a trust? So real estate and trusts.
Great, excellent. I want to, those are very different questions though. The first one was selling a home that is held in a trust. This one is the simpler one. And the short answer is, as you are serving in all those roles, right? The grantor, the person that put that into the trust, and the trustee, the person that controls that trust or the assets in it. Absolutely, you can sell that real estate, and in fact, the real estate world is so used to this that they don't even bat an eyelash. Oh, sure, you put your home into a trust, sure, and you're the trustee, absolutely. The second question, Hannah, can you repeat that one again? I want to make sure I understand it.
Yes. Does home ownership by a surviving spouse go to the next in line, such as a son, if the house is in a life estate or trust?
The short answer to that is no. It is controlled by the trust, by the terms of the trust. And that is a place where it is very different whether that real estate is going to pass through the probate process, which, unless the will said something else, they typically give to beneficiaries are the children. But again, the will would dictate those terms if it was not held in a trust, whereas in a trust, the terms of the trust will dictate.
Kristen asks, can a trust have more than one successor trustee?
Yes, and this applies to whether you have more than one, meaning you have joint successor trustees that will be listed to act simultaneously after you, right, when you cannot act due to incapacity or death, and or it can list a full list of several successor trustees, meaning at my death or incapacity, this person will serve. Or if they cannot serve, then this person, then this person. Frankly, it's very good to have successor trustees listed, and several of them.
I'm going to ask one more trust question, and then we have several questions about powers of attorney. So Janina asks, is there a problem with a person being the trustee of his or her own irrevocable trust?
Irrevocable trust. That is something I didn't speak to as much in my presentation. No, there's not necessarily anything wrong with that, other than we do need to distinguish between what is a revocable versus an irrevocable trust. Again, that's another one that I like to say slowly, kind of like state estate tax. A revocable trust versus an irrevocable trust, which generally means the things that you put into an irrevocable trust are going to often be more protected from creditors, but you will have less control over them. The problem is not so much who is the trustee, but making sure that we are making the correct decision up front, meaning if at some stage of life I want to make sure I have a lot of access to these assets, an irrevocable trust in that stage is not necessarily the best route. So that's more the crux of the question that we approach there.
All right. So we've had a couple questions about power of attorney. Brittany asks, would you recommend a durable power of attorney or having the general and advanced directive separate?
Yes. We separate our documents, though they certainly act in concert, in part because we want to allow our clients to name different agents, perhaps for different areas. Specifically here, I'm speaking to the general powers of attorney versus medical powers of attorney. And so those documents are separate, and in fact, the advanced medical directive, or the shorthand living will, is another document as well. But you will see different attorneys, different offices put them together different ways.
All right. Barbara asks, should parents give their child a limited power of attorney or full power of attorney?
That is a very, that one is up to the client. We will guide the client through what these powers are. But what we tend to advise, is as you are giving powers one way or another to an agent, and they are going to be fairly broad powers in a general power of attorney. Make sure you're giving that to a person that you trust. And in the case of this question, a child, that's essentially the analysis that the client would have to go through.
We have another question about living wills. Can medical professionals override a living will?
That one is case specific, but the short answer is sometimes yes. That can come down to when their oath comes into meaning the Hippocratic oath but that is why we do make sure we make it very clear in that language that we make sure that we advise our clients, let your agents know that you've put this this document in place, and we want, some folks put these documents together and think, okay, I've checked that off my list. There are several steps after you've put them together, and one of them is to make sure your agents know, A, that you have listed them as agents, B, what your wishes are, to try to make sure something like that does not happen.
All right, a couple different people have asked for examples of digital assets. What are digital assets, and can you give some examples?
Sure. All of these social media accounts that we have. And in that scenario, we try to make sure we give some examples, but don't limit it, because isn't that always changing, right? All of these social media accounts and a new one. Also, we do tend to make reference to online digital assets, meaning if you have things in a certain Venmo, PayPal account, that kind of thing. And so it is usually crafted to refer as broadly to our increasingly online personalities and lives that we have.
I've had this question from a couple of different people. If I, in the state of Virginia, want to handwrite a will and have it notarized, is that a legal will?
Yes. In shorthand, yes. Now, it might have to go through a couple more hoops at the probate step to make sure that we have evidence that this was the will, the intent. But there is essentially we want to allow people to put in place their wills. That said, we also want to make sure that that they have some evidence that this was their will, and that's why we tend to go through steps to make sure make sure our documents clearly convey that.
All right. I'm going to ask the elephant in the room question. About half a dozen people have asked this question in the chat and in the Q&A box. What is the cost of a will? And is there a cost difference between getting a will, a trust, an estate plan, or all together?
Yes, I'm largely going to punt on this question, and most of you knew I would. And in fact, I'll give the good old lawyer answer. It depends. However, yes, we tend to put our estate plans together as packages and make sure that all of these documents are together. And in fact, it is most beneficial to the client to make sure. Now, as you might guess, a flexible document like a trust will be more costly, but does deliver the benefits that I discussed. And in a trust-based estate plan, there's also always that pour over will. So you're additionally making sure that you get kind of that safety net will there as well. But no, I could not even answer that because different attorneys, different offices will charge different levels there.
Would you advise shopping around for estate plans?
Yes, I mean, lawyers across fields will tend to tell you, do your homework, do consult, and absolutely can be beneficial.
All right. One more question about a trust, and then I think this will be our last question. If you asked a question that I didn't relay to Brian, it's because we got a lot of questions, and some of them are very specific to certain situations. So if you have a very specific question for a lawyer, I highly recommend that you reach out to the Virginia Bar Association or even the Alexandria Bar Association. You can get a consult pretty cheaply to ask your question. And again, Brian's email will be on the slides. So if you would like to reach out to him specifically, you can do so. The question is, retirees get a tax break from selling their home. What happens to this if the house is made an asset of our revocable trust?
I'm sorry, can you ask that one again?
Retirees get a tax break when selling their home. What happens if the house is made an asset of a revocable trust? Does that tax break still apply?
Yes. My short answer is yes, that you are still the grantor and the trustee. So it would be, you are that person still. And that's why, in the real estate industry, they don't even bat an eye at that kind of thing. But a very good question there, yeah.
All right, I said that was our last one. We're actually gonna do one more because it's such a great question. Jeff asks, and this is my favorite question of the night, where should these documents be stored and who should have copies?
Yes, okay, so different offices might take different approaches to that. Here at Small & Plevy, we do offer to store your documents, and we have a very safe, locked place to store originals. Increasingly, offices don't do that, but if you are going to retain the documents, make sure they're safe. I do like to say that also make them accessible. Remember, especially if we're talking about a will, the original will have to go through probate. And you get folks who put these in a safe that only they know the code to. Well, the only person who knew how to get into that safe is you, and we're talking about a scenario where you are not with us anymore. Okay, so it does need to be accessible by at least someone who can have access to those documents. Now, in the scenario of powers of attorney, a copy is as powerful as the original, and distributing to your agents is a very good idea. But contrast that to what I just said about wills. The original is that document that we need for probate. And so there are differences from document to document, but someplace safe, someplace dry. Some folks get fireproof safes. That's not a bad idea. And that's the general answer there.
All right. So do you have more that you'd like to?
Pretty much just my little thank you. Again, I told you I'd be sharing some pictures. Here we are apple picking. And again, this was the reason I got into the industry in the first place. I really appreciate, Hannah, your time, and to all the attendees out there, your time as well. And I'd be happy to hear from you if you got more questions that we didn't cover. But everybody stay safe. Have a wonderful night, and thank you.
Thank you so much, Brian. I'm going to share in the chat the Alexandria Library, myself and another librarian put together a death literacy guide. So in addition to some estate planning resources, it also has some grief counseling resources, some general interest if you're just fascinated by death and want to read some books, funeral planning resources, and other things of that nature. I also host a monthly death cafe that's open to everyone. We're doing them via Zoom through the rest of the summer. A death cafe is where people just come to drink tea. Bring your own this time. When we're back in the building, I'll provide it again. People drink tea and they talk about death, and there's no agenda. We don't have a set list of things we're going to talk about. It's just whatever the group wants to talk about. You can talk about death without feeling like somebody's going to call you morbid. Our next one is going to be on Saturday, June 20th at 3 p.m. You can register for that on our website. If you click on that death literacy link that I just put in the chat box, it should have a button with our upcoming death cafes. And if you signed up for this program using an email, you will receive an email tomorrow with follow-up that includes Brian's email address, the link to the death literacy guide, and a link to the upcoming death cafe. Thank you everyone for attending.
Thanks so